anyone made any threats or promises to you, Mr. Mary, for you to plead guilty to this charge?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today?
Yes, ma'am.
And intelligently and voluntarily. Are you satisfied with your attorney's services?
Yes, ma'am.
Has he done a good job for you?
Yes, ma'am.
Do you have any questions for the court or for your attorney before I proceed?
No, I don't.
Then as to amended count 2, possession of THC as a misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt, or actually as to count 3, possession of drug paraphernalia, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of amended count 2 and count 3. Count 1 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Ms. Rockow.
Your Honor, I'd ask you to adopt the joint recommendation for court costs. Mr. Mary did complete an alcohol and other drug assessment. There were no recommended follow-up treatment, anything like that. So I think that cost is appropriate. Also, Mr. Mary had a very small quantity of THC in his possession. It looks like the officer weighted at 0.54 grams. So I think this is in the public interest. Thank you.
All right, thank you. Mr. Pollack.
Your Honor, I concur with Ms. Rocco. I also believe that Mr. Mary was honest with the officer when he asked if that was the THC was in fact his. I think he admitted that fairly readily. He was arrested that night for what it's worth, and that was May 3rd of 2024, and the $250 cash bond was posted on May 6th. So it appears he did have approximately 4 days of credit, although the recommendation is for court costs. It's worth noting there was some punishment and some time that he spent in custody. I don't believe 3, 4, 5, 6, 4 days, Your Honor. He has no additional open cases or anything that I'm aware of. The primary issue with this was simply getting funding from the Mille Lacs Band so that he could have the assessment done. Once that actually occurred, as Ms. Rocco stated, they did not find that he was high risk or high need such that he needed any sort of detox or follow-up or anything of that nature. This is a situation where he's engaged with his tribe in Minnesota, appears to be doing very well. I don't think that there would be any benefit to placing him on probation at this point and returning him to Burnett County. So I think this is an appropriate resolution, and I urge the court to adopt it.
Thank you. Mr. Mary, do you care to make any statement here today? You don't have to, but it is your only time to tell me anything.
No, ma'am, I'm fine with everything.
All right, thank you. All in all, in looking at the facts of this case and knowing what you did going and doing the AODA assessment and that follow through and having some connection with mental health specialists as it relates to any alcohol and or drugs, I don't find this to be an extremely serious case. You do live in Minnesota, in Hinckley, Minnesota. In Hinckley, Minnesota, THC is legal. In Wisconsin, it is not legal. Therefore, you can do what you will in the state of